Alright, so we've had some changes coming to Queensland property law that are set to come in August 1st,
We have
2025, which is not very long from now, is it?
Yeah, a week from now.
It's come up quick.
It has.
Yeah, so I've got Aimee here from Zip Conveyancing.
Yeah.
Thanks for coming in, Aimee.
It's okay. Thank you for having me.
It's okay. We're just going to take everyone through, hopefully, a simple approach to what this all means.
Yeah.
I sort of use a bit of a cliche with my son. If I can explain something to my 5-year-old son and he's like, oh yeah, then I know I've done a good job.
You've done a good job.
Yeah, where if he's like,
hopefully we can do that today.
Yeah, so we'll keep it basic and simple because there's a lot of, I guess, legal jargon and terminology where people can get a bit confused. So we'll use some real world scenarios where this will help people.
Yeah.
And then hopefully everyone picks it up and understands. Because I've seen it already on the news and on socials.
And YouTube.
Yeah, but it does seem to be a bit of legal terms. So let's try to actually give someone a real world example and explain how this is all going to work.
Let's do it.
Cool. So if you don't mind explaining exactly what these searches are currently. So searches, we're really just talking about information about a property, right?
Yeah, that's right. So a search is basically like an official check that you can do on a property to see if it's subject to flooding or bushfire or like development constraints, and it's basically just doing like a behind the scenes check to see if there's any adverse matters that can affect.
So as you know, Aimee, there's a lot of changes coming to the property law space as of August 1st.
Yeah.
So can you just explain a little bit about these changes for us, please?
Yeah, so there is a lot of legislation changes coming in. As a part of that, there is a requirement of sellers of property to provide buyers with something called a disclosure statement and also copies of searches that relate to the property.
Yeah. And up to this point, that's been the responsibility of who?
The buyer.
The buyer.
So yeah, currently when a buyer buys a property, they have the responsibility of ordering searches and making inquiries. And just so you know, a search is something that basically will provide us with information in relation to the property, like for example, flooding or bushfire prone areas and development constraints. So currently the buyer has the responsibility of looking into all those things, and if they choose not to do that, then that's on them. But so currently the position is like it's buyer beware, like purchase at your own risk kind of thing.
And so if you sold your property on July 30th, that would be the case.
That is the case, yeah.
Yeah, and then switching over to August the 1st.
That's right.
How will that work now?
The responsibility essentially flips to the seller.
Yeah.
The seller will have to do searches and provide a buyer with a document called a disclosure statement, which is basically they just compile all the searches and complete the disclosure statement based on those.
Yeah.
And the whole idea of it is just basically to provide buyers with transparency and I guess avoid discovering like surprises later down the track.
Yeah. And this is really one of the only states that has that pre-August 1st legislation, right? Like there's a lot of states that it is already the responsibility of the seller. So if you've sold a property, Tweed, for example, you're 5 minutes away from Coolangatta, but you would have been doing this anyway.
Yeah.
So it's really only that change for Queensland property buyers and sellers,
Yeah.
Okay, so let's use a real world example in terms of how this will or would have worked prior to August 1st.
Yeah.
So we've got, and we did this for our own benefit. So we've got Bob and Sally.
We do.
So Bob for buyer.
Yes.
And Sally for seller.
That's right.
Again, keep it as simple as possible
for
us so we don't have to remember. So you've got Bob buying a property off Sally.
Yeah.
So Bob would put an offer in on the property. Sally accepts that offer.
Yeah.
And so what's Bob's responsibility in terms of searches from that point?
So Bob has 100% responsibility at this point, and say Bob's dream was always to build a swimming pool in his backyard.
Yeah.
He's buying Sally's property and he thinks that's simple, he just moves in, builds his pool. But what Bob doesn't know is that there's actually an easement, which is something that runs under the ground.
So like sewage or stormwater or something like that?
Yeah, that prohibits any physical structures from being built on that part of the property.
Yeah.
So Bob can no longer build his swimming pool that he's always dreamt of this.
Yeah. Or worst case, he does build it, but then finds out later and it's underneath.
Not sure he would get very far, but yes.
Well, people do build things without DAs, I suppose. So
yeah, well,
Not so much anymore.
That's a Bob problem.
Hopefully, but yeah, definitely would be a Bob problem.
So currently, before 1st of August, it's on Bob to look into those matters, check if there's easements, see if he has, if there's the option to build a pool or not.
Yeah.
Well, it's really on Bob's lawyer to do that, not himself.
Yeah.
And if he might sign the contract, go unconditional, he's getting excited, and then his lawyer turns to him and says, well, actually, there's an easement here and you actually cannot build a pool.
Yeah.
And well, too late, Bob's already signed the contract, gone unconditional.
Yeah.
And he has to settle, and he's obviously very disappointed that he has to settle without a pool.
Yeah. Okay. So it kind of makes sense to me that the onus would be on the seller now after August 1st, because the seller's lived in the property for a lot longer. They're going to know a lot more about the property than a buyer would. So it does make sense that a seller is responsible for providing as much information to a buyer as possible.
Yeah.
And that's what's happening as of August 1st. So that same situation where Bob buys off Sally, wants to build a pool at the back, how will that work after August 1st?
So after August 1st, Sally would have to provide Bob with full disclosure of the easement, and that would have to be presented to him before he signs the contract.
Yeah.
So he has to have all those documents in front of him, and that obviously means that he can then make an informed decision. And this is before he's even signed a contract. So he might receive this information from Sally and then decide, oh, this property isn't actually for me because I can't build a swimming pool and that's what I really want to do.
Yeah.
And he'll just move on to the next property. He's saved money and time. He's saved Sally's time and money as well.
Yeah.
And he just moves on to the next one, whereas previously he would have signed it and is locked in. So.
Yeah. Which again makes sense.
Yeah.
But there also is an issue in terms of when that disclosure is provided as well.
Yes.
So if you can explain a little bit about that and sort of what rights that gives a buyer if they're not provided with that document in time or at all.
Yeah. So if they're not provided with it at all, or if they're provided with it and it's incorrect, the buyer can still terminate the contract even once it's gone unconditional. So
which is a big one, hey? After you've actually gone unconditional.
So satisfied building and pest, satisfied finance, we're ready to settle, and up until the day of settlement, the buyer can turn around and say, well, actually, Bob could turn to Sally and say, Sally, you didn't tell me that these matters are actually affecting my property.
Yeah.
So I'm actually going to terminate the contract.
Yeah.
So, you lose the possibly the listing from a agency.
Yeah, because it's really our responsibility as an agent as well to protect our vendors and make sure that that information is getting supplied in time.
That's right.
Yeah. So real world example in terms of a property that has sold and is in between, say, going unconditional and settlement.
Yeah.
Theoretically, if you're not provided with that information, let's say you've got a 90-day settlement on a property, that's a long time, but a lot of people want to do that because they've sold and they need to buy somewhere else.
Yeah.
So they've given themselves 90 days to find a place, basically. So the property's gone unconditional, it's 90 days in between that and when they settle. A lot can happen in 90 days for a buyer. So they might see another property that they really like, they might have something happen with their family or their personal circumstances or their financial circumstances. So a buyer could actually look for an out.
Yeah.
And theoretically this gives them that if it hasn't been provided or hasn't been provided in time.
Yeah, exactly. Which is why it's really important to just get it done from the very beginning and, avoid any delays. You're not doing it rushed, so you're less likely to make errors and, just leaves less room for error, I would say. Yeah,
for sure. And that would actually be a bit of a unmitigated disaster for a vendor and a real estate agent.
Yeah,
if you've got, let's say, 88 days into a 90-day settlement, so you're 2 days away from settling.
Yeah.
And then the buyer comes through and is like, you didn't provide me with this information. They're looking for an out.
Yeah.
And then they can just walk away from this contract.
That's right.
Because you haven't provided it or provided it after they're signed.
Yeah.
And literally you're having to go back to buyers from 3 or 4 months ago.
Yeah.
That were looking at the property that are going to have moved on or they have going to bought something else. So you're literally starting back from square one again with your vendor.
Yeah.
If they haven't found another agent already.
Yeah, you've probably lost their
which they
trust
probably
at
should
that point.
if you have done that.
Yeah.
So like it is a big deal to actually make sure that it's provided in time.
Yeah.
And also like receipt of it as well. So whether it's done through an email notification or DocuSign or Anature, just a way that you can actually prove that you gave it to the buyer at that time, because you'll have like a date stamp on a contract as well, right? So your evidence of providing it needs to be before they've actually signed a contract as well. And that's where you come in.
Yeah, that is where I come in.
Yeah, so just providing contracts and just making sure it's all done in time.
Yeah, and preparing the disclosure and making sure it's emailed through, and you know, ideally you want to get some sort of buyer's acknowledgement to say that they received it, or similarly if you have a property that's going to auction, you want the disclosure statement needs to be provided to all registered bidders.
Yeah, that's actually a great point too, because it's a bit different at auction, right? So explain a bit about how that process at auction would work.
Yeah, so ideally you would send a copy of the disclosure statement to all registered bidders before the auction.
Yeah.
I'm not really familiar with what actually happens at the auction, but you can probably tell me. But I'm assuming sometimes you have people rock up that haven't registered and they do want to bid. And in that case, you still need to have the disclosure statement available for them to look at. So I guess what that's looking like is having a physical copy somewhere at the auction that they can review. Alternatively, you can have a link and you can send them
like a QR code or something.
Yeah, so that's definitely something that needs to be considered, because it's a bit of a loophole, I think.
Yeah, and because if you're a buyer rocking up to, because obviously we want to provide buyers with information about their rights too, so if you're showing up to an auction, then you need to expect that this is going to be provided to you, right? Because then you bid at auction, you're not provided with this information. It gives you an out really as well, doesn't it? Especially if you have bid really hard, and then a day later you wake up and you're like, oh man, did I go a bit hard at that auction, right? But you haven't been provided with that information. You can be like, well, I'm just going to walk away.
Yeah.
And then as an agent, you're stuck having to run another auction, or you're going back to lower bidders just to try to get them up to that amount. So it's important to make sure you dot your I's and cross your T's. All right, so we've gone through a fair bit of everything already. I just want to cover in terms of why you would get a lawyer or a solicitor or conveyancer to do this work instead of potentially an agent coming into your living room and saying that they can handle it in-house or handle it themselves. So, because we've been quoted really anything from sort of $600 to $1,500 for these searches up front. So it's going to be a bit of a cost when there's already a fair cost involved with selling your home already. But I think, why is it important to actually use a solicitor or a lawyer to do this for you?
Yeah, so we as lawyers, we're often conducting searches currently for buyers and sometimes sellers. So we're trained and we have the experience of ordering, like knowing what searches to order is like first thing that you need to figure out, and then also being able to analyze those results and then complete the form in accordance with those. So we obviously have the experience of doing that, and also if, like we discussed before, if the form's not prepared correctly or you don't order one of the searches and the buyer can then terminate the contract, that responsibility then falls back on whoever's prepared the form. So from your perspective as a real estate agent, you might not feel comfortable wearing that risk. So it's definitely recommended that you have a lawyer prepare the form, and again, just being able to do it with enough time so that you're not rushed. And I think ideally the best time to do it is when you're first appointed as the agent, first get the listing. Ideally you want to speak to your seller at that point and say you need to chat with the lawyer about getting searches and disclosure done, because again, you don't want to experience any delays, and I guess just give the lawyer enough time to actually do it properly and know that you can have confidence in what's being done.
For sure, and even if something comes up on it that you weren't aware of as the seller, it can actually give you time to be able to deal with that, or you might have to, depending on what it is, obviously do like a price consideration in terms of something that might be an issue with the property that you actually didn't know about.
Yeah, and we've definitely had that happen. You'd be surprised. Like, sellers don't actually know a whole lot about their own properties.
That doesn't surprise me, actually.
No, exactly. So that definitely does happen, and that's a good point, because that might change obviously your marketing campaign and your pricing and things like that.
Yeah, for sure.
Yeah.
All right, well, I think we've covered all bases.
I think so.
Yeah.
Thank you again.
No, thanks so much for coming in. I'm going to put some details about you and your business in the notes in case anyone wants. We'll do the same for us as well. So if you have any further questions about the Form 2 seller disclosure that's coming in August the 1st, you can get in touch with Aimee or get in touch with myself.
Awesome.
Thanks so much for coming in, Aimee.
Thank
Appreciate
you.
it.